Hello, this is Matt on the Moon Lambo channel, and boy, do I have a treat for you today. Attorney John Deaton, just several hours or so ago, put out a synopsis of the SEC versus LBRY summary judgment transcript. And so it's just a synopsis. The actual, this is ridiculous, the actual transcript, apparently we're not going to get for 90 days. I saw this yesterday from the official LBRY Twitter account. They wrote, the SEC has requested the transcript of our most recent hearing be sealed from the public for 90 days. Someone knows they effed up. So folks, the fact that they even file that request means they don't want you to know anything that's within that. Obviously, they're just trying to delay because it makes them look bad. That's because they actually are bad. They're actually terrible creatures that nature accidentally made. I no longer believe in evolution as a result. I'm telling you, they're that bad. They're actually that bad. But this is amazing. So I've only skimmed through this thread to this point, so we're going to get to experience most of this together for the first time here ever. But I'll tell you this, like, it is scary what the SEC is actually arguing here. And so don't think that this doesn't matter to you, just because, look, I understand this is an XRP-centric channel. This matters to you. This is the SEC, and this is the type of approach that they're taking. This is the crap that they'll be arguing undoubtedly. And if we get to summary judgment in the SEC versus Ripple case, everyone in crypto should care about this. It shouldn't just be LBRY and XRP holders that care about this. Everybody should care about this. And you need to see just how twisted the minds of those at the SEC actually are and how they're actual sociopaths. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, Attorney Jeremy Hogan has already read this thread, and here's the thoughts that he shared regarding that. He wrote, great thread about the SEC v. LBRY summary judgment hearing since the SEC requested we, the public, not see the transcript for 90 days. And it's as summarized by someone who was there in person. The SEC's reasoning is rather remarkable. And that's why I said, even having just skimmed through this, it's completely absurd. You're going to be ripping your hair out by the end of this. But Attorney John Deaton was actually there in person, so who better to get this information from than somebody who was actually sitting in the courtroom taking it in firsthand. This is a firsthand account, right? And so anyway, it reads as follows: a synopsis of the SEC v. LBRY summary judgment transcript. As I said during Crypto Law's live stream, after watching the SEC versus LBRY summary judgment argument below is my single biggest criticism and observation along with direct quotes from the hearing. The judge asked the SEC's lawyer, quote, do you concede that there is what I think LBRY is calling a consumptive use for LBC, end quote. And so just note that LBC stands for LBRY credit. That is the LBRY token. The SEC lawyer responded, quote, we do, Your Honor, not for the entire time of the offering, end quote. Okay, so there. They acknowledge that the LBRY credit is actually being used for consumptive purposes, so meaning not just speculation, which is important, actually. Attorney Deaton continues. He wrote, the court said, quote, when does something that has a consumptive use and that LBRY would say is a commodity shade into a security, end quote. And then the SEC lawyer, these will all be quotes, all right, unless I tell you otherwise. SEC lawyer says, well, Your Honor, I first would say that you don't start with the presumption that something is a commodity. You apply the Howey test first. The court said, I think it's undeniable that people are acquiring LBC for investment reasons. I think it's undeniable that people are acquiring LBC for consumptive reasons. How do I determine in a case where some investors are acquiring for consumptive and some for investment? So pause, can I just say, this is exactly why we all in the crypto space have been saying this is a different animal. The fact that something so easily goes from centralized to decentralized, it's not sufficiently being accounted for because you're not, even if you claim, and I saw Jay Clayton make this claim that We already count for like a laundry token that could be used for an investment purpose versus in laundry machines. So in theory, it's already covered. But the problem is they're not saying when a cryptocurrency is sufficiently decentralized, because if something's sufficiently decentralized, there's no longer a common enterprise. But then again, they're also saying, common enterprise, schmommon enterprise. It doesn't matter, right? They're even arguing that because they don't care. These people are terrible and they just want control. So it's not about an adherence to logic in the law. That's for damn sure. And so then the court continues and says, how do I determine whether in that case it meets the first component of the third element of the Howey test? The SEC lawyer says, Your Honor, I agree it is a tricky problem not fully addressed by the law. Well, that's something. And then the SEC lawyer continues. And in fact, there's a third possibility, which is what if someone buys 1,000 LBC wanting to spend 10 and hold on to 90? End quote. And then John says, the SEC lawyer then began to argue that the token purchaser's subjective intent is not important. The SEC lawyer goes on to say whether the token has utility is not important. See, this is where it gets scary. Something that you buy to use, it's still just a security because of reasons. The SEC lawyer said the following. I think it comes out... it just sounded weird to me. I think it comes out, can a reasonable purchaser expect it to profit? It's not do they, it's can they. Oh, okay, can they, not do they. Can they profit? Which is why when you try and apply this to anything else, like everything's a security. You know, like all your Beanie Babies are securities, right? You know, it's absurd. Anyway, and then the court said, I agree it's not do they, I agree it's can. And then the court gave a hypothetical, and this is in quotes here. If we could nail down that 75% of LBCs were used and bought for consumptive purposes, people realize that there are also promotion of this for investment, and 25% were buying because of investment. Would that make it expectation of profits? End quote. And then John says, the SEC lawyer responds by arguing the percentage of those buying for consumption, the users, versus those buying for investment doesn't matter. He said the following. This is the SEC. What's happening here is you can buy this thing. You can wait. LBRY can continue to develop its network and it will be more. End quote. Oh my God. Everything's a security, folks. And it's not even if it could be worth more. So you buy something that might be worth more. Holy freaking hell. Well, in this inflationary environment, you know, cars are going up in price, even used cars, right? Well, they have been. I guess they've been going down a bit this year, but up until that point, they were going up. Does that mean that for some period of time, automobiles, used cars, were securities going up in price? My gosh, this is absurd. And by the way, there actually were people that were flipping cars for that reason. Like they were buying them, seeing the trend, and then they were selling them for a profit. There were actually people that were like literally, there were people, like, there are videos about it on YouTube, damn it. Like, does that mean those were cars are now securities? Well, by the SEC logic, why not? That's how stupid this is. Anyway, and then the SEC lawyer said, this is another quote, therefore, whether or not I want to take part of it and spend it on my cat videos, it's still expectation of profits if I am a reasonable purchaser. Can a reasonable purchaser expect profits as opposed to what is the reasonable purchaser's intent? And then the SEC lawyer says, it doesn't matter that there's a utility, because there was a utility in the oranges and the whiskey casks and the chinchillas and all the other cases that come along in the Howey chain. The utility doesn't matter. You know, so pause to think about this. And I've highlighted this on my channel before. I didn't pull it up for the purposes of this video. But Attorney Jay Clayton, as I mentioned a couple minutes ago, he cited that something can transform. He cited this example when he was speaking, I think, in front of students at it may have been a university. But he was citing an example that he made up of a token to be used for laundry purchases versus it representing an actual investment in the firm. Well, okay, but Jay Clayton even said in that example, which had nothing to do with crypto, that the utility actually does matter. He said that it can switch from one to the other. It can be security and then non-security. Jay Clayton said that. And now here you have the SEC saying utility doesn't matter, period, no matter what. That's what they're arguing. Everything's a security. This cannot be allowed. This cannot be allowed. John Deaton continues, the LBRY lawyer argued basically that the judge should adopt a principal standard. In other words, if LBC tokens were acquired principally for consumption and use, it isn't a security. He gave an example of, who is this, Naomi Brockwell, as someone who built a business utilizing the platform. So this is a tech journalist on YouTube, okay? And then John says, as you can see from the SEC's lawyer's argument, the SEC believes utility is irrelevant. According to the SEC's argument, even if 100% of the purchasers intended to use the token, if it can be held that a reasonable purchaser could also expect price appreciation, it's a security. Again, my extreme criticism regarding the LBRY lawyer's argument is that he did not give the judge a way to split the baby and find for both the SEC and for LBRY. One of the judge's first questions to the SEC lawyer was, when does a commodity turn into a security? I was expecting the LBRY lawyer to flip that question and tell the judge that the relevant question is, when does a security transform into a commodity? Oh, that would have been beautiful, right? Because that is the question, because any cryptocurrency that starts, that I've ever seen, that I can recall off the top of my head anyway, they all started centralized, including Bitcoin, because there was once upon a time, a day, when only Satoshi Nakamoto was mining. Now, that's centralized, if I ever seen the definition with my ears. Like, that's definitely centralized. So when does a security, something that's centralized, transfer into a commodity? Excellent question. And then John Deaton says, Hinman's entire speech on Ethereum is about that very fact. Clayton agreed with the premise that a token can start out as a security, but later be a commodity. Hester Peirce's entire safe harbor is premised on that belief. The judge even stated to the LBRY lawyer, quote, what about when there were only 4 videos on the platform to review, end quote. But that was day one when LBRY became live. There are today over 15 million videos to review and 1.3 million users per day. I realize it may come off in poor taste to Monday morning quarterback and be overly critical of another lawyer. I'm not the best lawyer, and I know I've made my mistakes. But that was a glaring mistake and very concerning because of how the SEC will spin a potential win. I have to go back and review LBRY's written summary judgment to see if the transformation argument is sufficiently addressed. Maybe it is, and the LBRY lawyer believed he didn't need to raise it at oral argument. I hope that's the case because an all-or-nothing approach is bad. The other issue for me was that the fair notice defense wasn't argued at oral argument. The judge commented that it was well briefed, but he gave the parties an opportunity to highlight issues. Both sides declined. I would have argued the LBC token meets the standard articulated in Hinman's speech better than Ethereum does, and that LBRY relied on it. I know when I interviewed Jeremy Coffin, that's the LBRY CEO, on Crypto Law TV, he said his team did a PowerPoint presentation on the speech and how LBC met it. The judge is likely to decide fair notice isn't a defense. The Ripple XRP case is in the Second Circuit and has the Upton case as precedent. LBRY doesn't. There's a reason the SEC didn't move to strike the fair notice defense in LBRY as it did against Ripple. The SEC expects to win versus the fair notice defense in LBRY and then run to Judge Torres saying, look how it was struck down. The truth is the SEC is expecting a win versus LBRY, but it's really not about LBRY. It's about getting the LBC token declared a security to use against all of crypto. Think about it. Who is LBRY hurting? It raised a couple $100,000 with all the fraud and pump and dump schemes to go after. They go after little ass LBRY for a few $100,000. The SEC wants the win for what it means symbolically and politically. I tried to get attention to this case long ago. If I wasn't in the XRP case, I would have bought LBC and asked to file an amicus brief. I support Jeremy Kaufman and LBRY and hate to be negative, but Ripple should be ready to distinguish a ruling the SEC runs to show Judge Torres. It's kind of depressing in a way, man. I really hope things go well in the library case. I hope the judge, because look, the thing is, and that's a fair point that John Deaton brought up as far as the attorney not bringing up, what if, when does a security turn into a commodity? It's perfectly fair to bring up. The only kind of silver lining there, at least to some degree, is the judge on his own recognized, hey, this is a problem here. How do I know what to rule on if it's something that's being purchased for a consumptive purpose, and also for other people are purchasing it for an investment? So at least the judge is aware of that, but without sufficient argument, I don't know what that's going to mean ultimately. So I can see why John Deaton is saying what he's saying and expressing concern. It is concerning. This is a big deal for all of crypto. I'm going to be if this doesn't go well, and if, God forbid, the SEC versus Ripple case doesn't go well, I'm going to be very nervous about all of my other crypto investments that I've been holding for years. It's just like the SEC is trying to destroy all of our opportunities to achieve life-changing wealth, like in the United States. Like that's what they're doing. They're not protecting us. They are harming us and taking away our opportunity. And I'm disgusted by it. I really am. And it's very alarming. I'm legitimately concerned about this. I'm optimistic. Now, don't get too, I don't want to be too negative either. Like I'm still very optimistic, but definitely alarmed. We should be alarmed. We should be both optimistic and alarmed. That's what I think anyway. Please let me know what you think in the comment section below. If you got additional takes on this, it's a very interesting topic, but I'll wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.